Good afternoon and welcome to this webinar, Your Anti-Money Laundering Questions Answered. I'm Colette Best, I'm Director of Anti-Money Laundering at the Solicitors Regulation Authority, and I'm delighted to be joined by some expert colleagues who are going to help answer some questions. So today I'm joined by Ross Gilson, who's Head of AML Policy, Mandeep Sandhu, who's Head of AML Proactive Supervision, and Declan Brown, who's an AML regulatory manager. So this is a new format for us as a webinar. So we don't have any slides. What we've done is we're doing this purely on questions and answers. So we've looked at the questions that you've submitted ahead of this webinar and also questions that got submitted at previous AML webinars that we've done that we didn't get time to answer at those. And we've got some questions prepared. We've also got time to pick up some questions that come in over the course of the webinar. So do please get your questions over, and you can do that at the link at the bottom of your screen. We hope to have time for a few of those towards the end. In the meantime, we've got about 45 minutes for questions that have been submitted. And if you do need to dash away early, don't worry, the recording of the event will be available online. So I'm not going to take up any more time with a preamble. Why don't we get straight into the questions that we've had submitted? So the first question, one a bit about how we operate. So what's the difference between an on-site inspection and an investigation? What's a thematic review and what normally happens after an on-site inspection? So I'm going to hand over to Mandeep to answer this one.
Thanks, Colette. So an AML on-site inspection is something we carry out on a proactive basis as part of our supervisory remit. That's not an investigation, and it's there for us to assess how well you're complying with the money laundering regulations and monitoring your controls. There's 4 outcomes off the back of an inspection, and that can be, which is most of the common methods, is we work with firms to bring them into compliance. So you may receive a guidance letter where there's minimal amends, engagement where there's a few amends to your controls, or a compliance plan where there's more detailed amends that we need to make to your controls. And the final outcome can be a referral for the investigation team because we've found breaches of the money laundering regulations. An AML investigation is something we carry out under our regulatory remit, and that's where we assess any breaches or misconduct in line with our standards and regulations. And a thematic review is research that we carry out based on a theme, and then we issue guidance for the profession based on that. This year we're working on training for AML. Last year we worked on client matter risk assessments and published guidance, and we've also recently done the sanctions guidance off the back of a thematic review.
Super, thanks Mandeep. Why don't we move on to our next question, and I'm going to pick up the answer to this one. So the question is, there's been significant recent publicity about very substantial fines being imposed by the SRA, FCA and others for AML breaches. Does this signal a toughening of approach in this area, and should firms be worried? And where do AML fines go? So, as I said, I can speak for the SRA, I can't speak for other supervisors, but to pick up that last question first, AML fines aren't retained by us at the SRA. They, like all of the fines that we levy, go back to the government. In terms of the fairly large number of fines in this area that certainly we've levied recently, it's probably worth bearing in mind that quite a number of those cases are cases that have been in train for a little while. And some of these cases have been breaches of the regulations. Others have been where that risk has actually crystallised and transactions have taken place that shouldn't have. But where we're taking action for breaches of the regulations, that is a really key part of our role to make sure that firms have appropriate safeguards in place to act as a role as a gatekeeper to services and products that can be used to launder money. So that's why we do still take action if firms don't have appropriate policies, procedures, controls or systems in place that would actually leave the door open for their firm to be used to launder money. And then moving on to should firms be worried? I mean, we do work very hard with firms to help them be compliant. We've put out quite a lot of information to help firms make sure that they're complying. But where we do find that firms aren't doing what they need to do, we will continue to take action. And then just in terms of whether there's been a sort of a toughening of approach, I think probably the thing to mention here is that the regulations have been in place for 7 years now. So probably the approach does signify that actually firms have had 7 years to make sure their house is in order, and that breaches often have been going on for quite some length of time. And so the fines that we levy do reflect the length of time that that breach has been taking place. So I hope that's helpful. So let's move on to our next question then. So this one is quite a common one, and it's how far do I need to go on source of funds checks, and how can you check source of funds other than through a bank statement? So Declan, can you pick this one up?
Yeah, sure. Thanks, Colette. And as you say, this is probably the most frequently asked question that I tend to get whilst out and about on site doing inspections. You know, how many statements or what documents should we ask for when carrying out source of funds checks? Now, there's no real hard and fast rule for this. You know, you should take a risk-based approach, and that's going to differ depending on the client or the matter. And what I tend to tell firms, instead of focusing on, you know, or following a set rule for every client, what firms should ask themselves is, you know, one, do the documents that I've obtained correlate with what the client has told me? And number two, would I be able to reasonably evidence this to the SRA or to law enforcement if we ask to view the file? Now, we're not expecting firms to be financial investigators. So, you know, we're not expecting you to try and go through and understand every penny, but we do expect firms to take reasonable measures to understand the funds that are being used in a transaction. So, for example, you know, if a client has told you that they'll be purchasing a property using funds from their savings, which has come from their salary, you know, taking an extract from their internet banking showing the availability of the funds probably isn't going to be enough, because that doesn't show you the salary being paid into the account. If, however, the client provided a copy of their savings account statement which showed the account activity alongside perhaps a couple of wage slips or a couple of current account statements which show the funds being paid into the account, you may decide that does actually tally up with what the client has told you. It's probably worth mentioning at this point that just because the funds are held in a UK bank account, it doesn't necessarily mean they're clean. So unfortunately, you can't just rely on that fact. Ultimately, how far you go will be dependent on the level of risk, which is why it's important to carry out your client's matter risk assessments and to note down your thoughts or your rationale. The higher the risk, the more documents you're likely going to need.
Super, thanks, Declan. Why don't we move on then? So this is a question that a number of people have asked in various different formats. But what checks do I need to do on counterparties to a transaction? So Ross, are you happy to answer that one?
Absolutely, thank you, Colette. Well, there are a couple of different limbs to this one. The first of which it would be under the enhanced due diligence regime, where we're talking naturally about situations where there are already going to be various red flags in place and things which would cause you to have a heightened understanding of what's going on as a result of the risk that you've already identified. And 33(5)(b) of the regulations states that you may, as part of your enhanced due diligence measures, also take additional measures to understand better the background, ownership, and financial situation of the customer, that's your client, and other parties to the transaction. Now, situations where you might engage this might be where you have a suspicion that the other side may not be who they say they are, or perhaps who your client and the other side you thought were two separate parties but are actually somehow connected in a way that appears suspicious. So maybe if they ostensibly were separate entities but actually are under common ownership, then you might take these additional measures. Now, the important thing to remember here is that you won't have the same level of information as you do about your own client, and you won't have access to it. So you might want to look at things like, for example, companies' house records if companies are involved, or maybe to put the other side's client through your e-verification system if you have one. The other strand of this is to do with sanctions. Now, sanctions, as has been said before, is a strict liability regime. You breach the sanctions regime by committing an act, which may, for example, be transferring funds to or from a designated person. And as I say, that is strict liability. There is no risk-based approach here. You either breach it or you don't. Now, again, to protect yourself here, we always recommend that where you're transferring money, or indeed receiving it, from another party, that you just run them through the OFSI consolidated list search. That's quite easy to find. You have a look on Google and write in search consolidated list, and it should bring up the search tool. You can apply a fuzzy search if you're not sure of the spelling of a name, and this will allow you to do a basic check of whether or not they are designated for sanctions purposes. And that, it's not necessarily the end of the story. Ownership and control, as we've addressed in other webinars, is quite an extensive topic, but it should give you at least an initial indication of whether there's likely to be a problem. Now, as we say, it's free, it's easy. We always suggest that that happens due to the strict liability nature of the regime. It also might be something you want to do if, for example, you're a bit worried about whether the other side might be under the aegis or acting on behalf of another party. And then, for example, if you get a name match, you want to look at dates of birth and things to check if they are in fact the same person as the designated person on the list. And do what you can to give yourself comfort. As I said, in relation to enhanced due diligence, you won't have access to the same information as you do about your client. So it's about building up a picture from the information you have available. Thank you.
Super. Thanks very much, Ross. So, all right, let's move on to our next question. So this is another one for you, Ross, and quite a detailed question. So we'll see what we can get through in sort of a couple of minutes. But what's in scope of the money laundering regulations and what's out of scope? What checks do I need to do on matters out of scope? So over to you again, Ross.
Certainly. Well, in terms of what's in scope of the money laundering regulations, we have produced quite detailed guidance on this point. There is going to be a situation, for example, where things are in scope, if it involves tax advice that you're providing, either via yourself or a third party, or various other criteria involving monetary transactions, transfers of shares and the like. The important thing to remember, though, is that what brings something in scope is an activity, not an area of law. So if you're setting up a trust, for example, that would fall within scope regardless of whether it's being done by your probate department or by your litigation department, maybe as part of a PI trust. So have a look at that guidance. If you just Google the scope of the AML regulations, SRA, or something like that, you should be able to find it. In terms of what's out of scope, so we're talking here potentially about things like the conduct of litigation itself, maybe your employment law or family law, then you are under an obligation under the standards and regulations to identify your clients. That's not the same as identifying and verifying them under the money laundering regulations, but you do need to know who they are. In terms of what checks you might want to undertake, though, it is always worth remembering that even if the money laundering regulations don't apply, the Proceeds of Crime Act still does. So you'll want to be quite careful about receiving and transferring funds, because people may try to use transactions and transfers out of scope of the regulations as a way of avoiding scrutiny. So take common sense measures. If your client is behaving unusually, for example, or if there are other red flags that pop up, such as being unduly pushy, then you would want to take some further action and maybe think about putting in a suspicious activity report. Again, we've produced guidance on the Proceeds of Crime Act, so if you just Google SRA Proceeds of Crime Act guidance, that should give you an understanding of what the obligations are. Thank you.
Super. All right, thanks, Ross. So we're whipping through these questions. So why don't we move on to the next question? So this one is from a small firm. So they say, I'm a small firm. Do I need to get an external audit? How often do I need to get an independent audit? And how do I know whether the auditor is independent? So Mandy, can I hand over to you to answer that one?
Thanks, Colette. Sure. You don't have to have an external audit. The requirement is for the audit to be independent in accordance with the regulation. So what that means is anyone who's put or input into the firm-wide risk assessment or policies shouldn't be carrying that audit out. So as long as they're sufficiently independent from the money laundering reporting officer and compliance officer, it's fine for the audit to happen internally. It just needs to meet the requirements of Regulation 21. And unfortunately, we have seen external audits where they don't fully meet those requirements. So be really sure what you're signing up for. And those requirements are that the effectiveness of your policies are considered as well as the adequacy. So there will need to be an element of our reviews to see how well your controls are working. In terms of the frequency, you can take a risk-based approach in terms of how often that occurs. And some of the good prompts are to see if there's any changes to your practice, changes to the number of fee earners, changes to the work you do. So that should normally give you an indicator of how often you want to carry that audit out. And depending on the recommendations and findings, you might also consider that you need to do one again after a year, or if the findings are quite minimal, you might decide that a bit of a longer lead-in time is fine with that.
Splendid. Thanks, Mandy. All right, so let's move on. This is quite a topical one, I guess, based off the back of recent elections. So can voter ID be used as part of customer due diligence? And also, what do I do if a client doesn't have a passport or driving license? So Ross, what are your thoughts on that one?
Well, it's important to remember that the regulations themselves don't specify that you need a passport, a driving license, a council tax bill, or whatever in order to act for your client. What you need to do is identify them and verify them. So identification is, for example, having photo ID and seeing them in front of you. Verification is something that supports that. And quite often, just having a passport and, say, a council tax bill or a utility bill is an easy way of achieving that. But it's not the only way. For example, if your client was in, say, a care home and they didn't have a current passport, they didn't have utility bills, maybe you could look at an expired passport coupled with, say, a bus pass or perhaps a letter from their doctor, and in the same way form a picture of them to make sure that you are certain about that they are who they say they are. It is important, though, to think about the evidential value of the documents that you're using. So a voter ID, for example, I had a look at it online this morning while preparing for this, and it's an online form that you fill out where you need a digital ID as a digital photo of yourself and your NI number. Now, that's a considerably weaker set of requirements than for a driving license or a passport. So with voter ID, you might want to see something else as well to make sure that the person is who they say they are. You might also want to consider a few things like how far out of date or how new this is, and whether it fits with the picture that you have of the client overall. But there are plenty of ways to identify and verify. Passports and utility bill, as I say, a convenient way of doing it, but by no means the only way. Thank you.
Brilliant. All right. So let's move on. It's another one for you again, Ross. So I'm a high street conveyancing firm. Do I need to do a proliferation financing risk assessment? Over to you, Ross.
Well, I'm afraid that the answer to this one is indeed yes. It's a strict requirement of the regulations that everybody who's in scope does a proliferation financing risk assessment. However, the degree to which you need to do it will vary. We have set out in our sectoral risk assessment that we consider that the general risk of proliferation financing among the solicitors' profession is low. Some firms, however, engage in activities and areas which might heighten their risk. So these include, for example, trade finance, commercial contracts, manufacturing, so perhaps in relation to dual-use goods which have both a peacetime and a wartime application, commodities such as mined metals and chemicals, shipping or maritime, military or defence, or aviation. If you're not acting in those areas, then it would probably suffice for you just to think about whether there are any risks which might be posed to your firm by proliferation financing, and if there aren't, just saying we consider ourselves to be at low risk having thought about it. Now, certain things might modify this. For example, if you have a particularly if you have a set of clients, for example, that get their money from any of those industries I've just listed, you might want to have a bit more of a think about whether those pose a risk to your firm. But by and large, most firms should be able to just say, we've considered it and we consider the risk to be low, and that can be folded into your firm-wide risk assessment without needing to be a standalone document.
Super. All right, thanks, Ross. So why don't we move on? So this is a very common question. How far do I need to go to identify ultimate beneficial owners of large corporate entities? So Declan, I'm going to pass over to you on that one.
Yeah, thanks, Colette. So I guess before we answer this, we just have to think about Regulation 28 really, first of all. And to paraphrase that, Regulation 28 talks about taking reasonable measures to verify the identity of beneficial owners so that the relevant person can be satisfied that it knows who the beneficial owner is. Now, what does that mean in practice? Well, the purpose of that is so that you know who the true individual or true individuals are who sit behind a corporate structure and who ultimately benefits from any profits. Now, by verifying this person's identity, you can then run further checks on them to make sure that they're not linked to any sort of criminality. Now, how far you go with that should be done on a risk-based approach. So, if you're dealing with a large, well-known entity, for example, Dyson, where there's lots of open source information out there around who the ultimate beneficial owner is. So in this case, James Dyson. You may choose to rely on open source information that you've taken from your searches. If it's a lesser known entity or a smaller entity, obtaining a copy of the beneficial owner's passport and their utility bill may help you with your checks. It's also worth noting that if a company is listed on a regulated stock exchange or a regulated entity, you may choose to carry out simplified due diligence. Again, that will be dependent on the level of the risk in the matter. And any decisions you make, again, you must make sure that you're noting down on your client and matter risk assessments so that you've documented your rationale.
Splendid. Thanks, Declan. So let's move on. One for you here, Mandeep. What are the advantages and disadvantages of having a centralized onboarding team?
Sure. So we've seen both approaches to centralized teams and fee earners directly doing due diligence and matter risk assessments, and there's good and bad practice in both. In terms of the centralized teams, some of the good practice we've seen is there's really good ongoing monitoring of the client due diligence, and there's a lot more experts in that team carrying out that research, particularly for complex structures. And there's also an ongoing monitoring of the risk. But where we see bad practice with centralized teams is there's a real disconnect sometimes with the fee earners who are actively acting on the matter. And sometimes they're not even aware that they're acting for a high risk client or a high risk matter, which is concerning. And even if it's not a high risk matter, if you don't know the risk of the client, if there's any changes to the retainer or the client, it's difficult for you to then flag to the centralized team when there are changes to the transaction. And then also some of the other bad practice we've seen is where a team or a client has been onboarded by the centralized team, where there's an ongoing retainer or different matters being opened, the ongoing monitoring isn't carried out on the basis that the retainer keeps coming forward on separate matters. And that's some of the bad practice we've seen, where a couple of years have passed and the due diligence hasn't been refreshed because there's been an ongoing matter for that client for some time. So in terms of centralized teams, they can work really well. Just be sure that your fee earners are involved in that process, that they're reviewing the due diligence and understand it, and that they are feeding into the risk level for the client and the matter for that to work well.
Brilliant. Thanks, Mandeep. All right, so there's one here that's been pre-submitted. We've also had this question come through just now. So the question is, I don't operate a client account. Is there a difference to the money laundering regulations if I don't hold client money? What is the risk here? So Mandeep, can I ask you to have a punt at that one as well?
Sure. So there is no difference between the requirements in the money laundering regulations, whether you operate a client account or not. And that's because even if you don't have a client account, you can still, be involved in an arrangement offence. So a good example of that is drafting documentation that might facilitate the movement of money. Could mean an arrangement offence occurs, and you don't necessarily need a client account for that. On a separate point, I probably raise that not having a client account, you can still be exposed to sanctions risk as well. So for example, if you act for a designated or come across a designated person, you wouldn't be allowed to take fees into your office account without a license, and also take into your account make any payments or take any money from designated persons without a license to do so. So not having a client account doesn't necessarily equate to lower risk.
Brilliant. All right, let's move swiftly on. So this is one about using electronic due diligence providers. So are there any electronic due diligence providers that you've seen who are particularly good, and how can I choose one? So Declan, any that you've seen out and about?
Yes, I get asked this question again quite often whilst out and about on site. Unfortunately, we're unable to endorse any particular providers. There's loads out there nowadays. I think a lot of these providers have moved on from just doing politically exposed persons or PEP and sanctions checks. Some now offer liveness checks, and some can even help with source of funds. We have no preference at the SRA, in terms of which electronic provider you choose, or whether you choose to use one at all. Whichever electronic provider you do choose to use, it should work for you and your firm and whatever budget you have in mind. And whichever provider you do go with, you just need to understand how it works, essentially. So, where it's pulling its information from, how that information, you can tell that information is independent, so it helps you meet your requirements of Regulation 28, and also any potential limitations of the system or provider that you're using. Ultimately, it's down to you to decide whether the level of comfort derived from a search or a system is adequate to mitigate the money laundering and fraud risks which your business is exposed to, and that should be documented in your firm-wide risk assessment.
Brilliant. Thanks, Declan. So let's move on to another question about due diligence and due diligence providers. So what steps should we take when our third-party provider of ID checks flags up that a director of a new company has a similar name to known terrorists or people with terrorist links? So Mandeep, can you pick that one up?
Sure. So the first thing you should be doing is carrying out enhanced due diligence on that matter, and doing further probing and understanding more about that client. So checking their date of birth and if that matches to the known terrorist. HM Treasury do have a list of both domestic and international terrorists, so you might want to check against that list as well. You've mentioned it's a new company client. I don't know if you mean it's a newly set up company, in which case that might be a red flag that you want to look at in terms of why that company is being set up, or if it's a new company client that's approached your firm, in which case if it has, you might want to probe further as to why they've approached your firm, or the reasons behind that transaction. And as part of your client and matter risk assessment process, you should be really probing into the purpose of the transaction that they're instructing you on. And finally, if you do find positive matches after doing your enhanced due diligence checks, you might want to consider submitting an information SAR to the NCA, because they'd want to know if terrorists are accessing legal services and what they're trying to access, or if it's a purchase, for example, that they're trying to, move their money in that way.
Brilliant. Thanks, Mandy. All right. So a few more, and we're sort of at the hour, so let's do a few quick fire questions. Ross, can you explain the changes to the requirements on PEPs, politically exposed persons, please?
Well, this was a change that came in at the end of 2023 and came into force on the 10th of January this year. The regulations have now been amended so that if somebody is a domestic PEP, that is one who holds a public function within the United Kingdom, they are still to be subject to enhanced due diligence, but to a lesser extent than a politically exposed person who's not from the UK. Now, what that actually means is going to be explored by the FCA when they produce some guidance. They consulted about that earlier this year, and they're due to be reporting back on it at the end of next month. So we're all waiting to see what happens there. It is worth pointing out that the exception to this, though, is that if there are other risk factors that mean that the client concerned may be subject to enhanced due diligence for other reasons other than being a PEP.
Brilliant. Thanks, Ross. And another one which we had pre-submitted and has also again just come in. So, Ross, can I pass on the costs of customer due diligence?
The answer to this is yes. You can pass the costs of the CDD that you do on a client onto them. The requirement is that you follow your other obligations under the standards and regulations to treat clients fairly and to be transparent in your billing with them. So make clear what they're paying for and where it goes, essentially. It's also worth pointing out that you need to be quite careful here as to whether you're listing these as disbursements or as profit costs, because I have come across some firms who have got into trouble with the VAT inspector as a result of charging or not charging VAT on things which should have been. So be careful with what's a profit cost and what's a disbursement. Make sure they go on the right side of the bill and be transparent with your clients about your checks. And of course, if, for example, you find that a matter becomes more complicated partway through and further checks are needed, then you will need to flag that up to the client that they're going to need to expect to be billed more on the same terms as before.
Splendid. All right. So one here about training. So Declan, which employees do I have to train?
Thanks, Colette. So it's quite a timely question actually, as I'm currently leading on our AML thematic this year, which Mandy mentioned earlier, which we're looking at training. Now we're looking to establish whether there's a link between sort of strong compliance and good training practices, and this is due to be published later this year. So please do keep an eye out for that. In terms of the regulations refer to all relevant employees. So that's anyone that's carrying out work or assisting with work that's in scope of the regulations. And that can be both fee earners and support staff. So, if you have people in the finance or accounts team, they'll also be classed as being relevant employees. In terms of what we're seeing from inspections, most firms generally provide anti-money laundering training to everyone at the firm, regardless of the type of work that they're involved with. The one benefit of that is that staff can then transfer across the business more easily. And secondly, it means that everyone that's at the firm is aware of their role and how they can prevent the part that they can play in terms of preventing money laundering. So it's worthwhile sort of thinking about as training everyone. Again, any training that you do provide should be appropriate for the post holder and the business area that they're involved in, relevant to and should be cover the risks that they're likely to come across.
Brilliant. All right. So let's move on then. So, Ross, If a client pays legal fees in cash, how can we ascertain that the money has not been gained through the course of criminal conduct?
Right. I think the first thing to say here is that legal fees, there's a general carve out from legal fees being subject to the proceeds of crime regime. This mainly relates to comes from the world of litigation, and it is intended to make sure that essentially the criminal justice and litigation system can still function. Quite apart from that, though, I think it's worth thinking, if you find yourself in this situation, why your client wants to pay in cash, and is this something you really want? So you might have various queries about, am I insured to have this level of cash on the property? What are we going to do with it? Where are we going to store it? If you can, the most sensible thing is going to be to try to get your client to pay it into a bank and then into your firm on practical terms, let alone anything else. Apart from legal fees, things like deposits, for example, would need to attract some scrutiny from you as to making sure that the source of funds, making sure that the client can evidence why they're being paid in cash, and is that a good reason? And then we get onto the sanctions regime. Now, this is slightly different to money laundering in that sanctions applies to everything, including legal fees. There are a couple of legal fees, general licenses in place. You would need to make sure that payment in cash wasn't some way to circumvent this, for example. You would also need to, as I say, really understand the reason for this, whether this is an attempt at circumvention of the sanctions regime, why the client wants to deal in cash in this way, and on practical terms, again, why would you want to accept this? In terms of ascertaining where it came from, if you want to go down that road and make sure that you're absolutely sure that you're not going to be dealing with this, you might want, for example, to be seeing maybe letters from an accountant, maybe some sort of explanation of where the money came from. So, for example, looking at, for example, if they've inherited a lot of money and just kept it in a mattress, maybe they can show you a grant of probate or something that shows the money due to them. But by and large, this really is a situation that you want to avoid as much as possible on both practical and risk grounds.
Okie dokie. So let's move on. So this is one about documentation. So is it absolutely required to have a formal document to show compliance? My files confirm source of funds, ID, etc. So Mandeep, can you talk about what documentation we expect to see?
Yeah, so the short answer is yes. You do need to have records to show, because it'd be difficult for you to evidence that you're complying with the regulations without that evidence. But it's aside from that, directly in the money laundering regulations, Regulation 40 asks you to keep those records, and that's a mandatory requirement. As well as for your AML policy under Regulation 19, you have to have a written policy, and you need to demonstrate that you have that to us as an AML supervisor as well. But it doesn't stop there. Aside from having a written policy, you should also have evidence of any updates you've made to those policies, as well as evidence of how you communicate those updates to those at your firm. And the ELSA guidance also confirms that position and asks you to have a written record of all of the aspects of the regulations, including the firm-wide risk assessment and your client and matter risk assessments.
Brilliant. Thanks, Mandeep. So final of the pre-submitted questions, and we'll just do a couple that have come in live. So I'm an immigration solicitor with no client account. What do I need to do to prevent money laundering? So Ross, can you pick that one up?
I think it's important to say from the off that the money laundering offences set out in the Proceeds of Crime Act involve not only, for example, handling money or transferring it, and money for these purposes, by the way, means all sorts of assets, not just cash itself, but moving the proceeds of crime around, it can involve facilitation as well as actually doing it. So just because you have a client account, that is a big risk off your table, but it's by no means the end of the matter. You can still fall foul of the Proceeds of Crime Act. And the Proceeds of Crime Act is what would apply here. The regulations in the ordinary course of business wouldn't apply to an immigration practice. So, for example, you wouldn't be caught by the need to have firm-wide risk assessments, client risk assessments, and the like. I would refer you back to our Proceeds of Crime Act guidance, which gives some good advice on what to do if you're outside of the regulated sector. And I would also reiterate my previous advice, and although it's not strictly relating to money laundering, but to make sure that your clients are not sanctioned individuals. And you can do that for free and very quickly by searching Office's list.
Brilliant. Well, that brings us to the end of the pre-submitted questions. Thanks very much to everyone who's been submitting questions during the course of this webinar. We've had quite a lot through, and we've got 5 minutes left of our formal time, so we'll run over a little bit, but we won't get through all of them. But let's pick up a few interesting ones. So the first one that's come in was, how often would you expect to see our PWRA reviewed, our practice-wide risk assessment reviewed? Can you give us examples of what might trigger a review? So I think that's a really helpful question. I'll kick off on that one. So there's lots of both internal and external factors which might lead you to review your practice-wide risk assessment. I think probably I'd also differentiate between reviewing it to check that it's still correct. Just because you're reviewing it doesn't necessarily mean that you're updating it. So if you've reviewed your practice-wide risk assessment and sort of realised that everything is fine, just note down that at the bottom to say it was reviewed by X on X date, and then you're demonstrating to us when we come in and inspect you that you're keeping your practice-wide risk assessment under constant review. Things like big external events, so change, of course, in the regulations, change in high-risk third countries lists, change in SRA guidance are all good examples of external triggers that might mean you would want to review your practice-wide risk assessment, but also internal changes as well. So things like changing your software system, changing your areas of business, going into a new area of law. All of those we would expect to see reflected in your practice-wide risk assessment. And just from our perspective, we have our own sectoral risk assessment. We review that every quarter. That's not to say we update it quarterly. We update it when it's necessary, but we do review it every quarter. Mandeep, is there anything that I've forgotten there on updating practice-wide risk assessments?
Yeah, I think that covers most of the areas. The one thing I would mention is when we are coming out either by desk-based review or inspection, we are looking to see that you have now considered the proliferation financing risk assessment, and you can incorporate that into your firm-wide risk assessment, but we do expect to see that that risk has been considered. Some of the other risks that might prompt you to review your risk assessment, I think a good example was the pandemic with COVID. So, for example, a lot of firms had an increase in the conveyancing work that they did because of the stamp duty relaxation. So ordinarily, where you might have considered you do 40% conveyancing and that increased to 60%, for example, that should prompt a review of your risk assessment. And then obviously there's been a lot more remote work in terms of onboarding remote clients since the pandemic. So that should have, those are key indicators of areas that might prompt you to review your risk assessment because of the changes that are occurring within your firm at that time.
Really good, great points. Thanks, Mandy. So this is one that's come in about source of funds over the course of the webinar, perhaps just as a clarification. So rechecking source of funds, are you saying you should always get a bank statement to demonstrate source of funds from a standard or low risk client? So Declan, are you happy to expand on your sort of comments and thoughts on that? Oh, and you're on mute, Declan.
Sorry, the problems with live TV. Yeah, I think the first thing to consider here is, bank statements aren't the be all and end all of source of funds. There are other ways that you can verify source of funds. If you're dealing with someone that's a quite extreme example, but if it's a fairly well-known celebrity or even a fairly prominent businessman in like a particular area, and there's a lot of open source information out there to help. Yes, you could potentially use that information in the absence of bank statements. I think the thing to consider here is your source of funds checks are probably one of the best ways to protect your firm. And I think what I would probably put back to the firm is, well, how have you arrived at the risk rating of being low or standard risk without doing them checks? If your starting point is actually you're treating conveyancing matters as being high risk, how are you then sort of knocking the rating down to low or medium? What checks are you doing to decrease the risk? Again, it's all about sort of noting down on your client and matter risk assessment about what your rationale and what your thoughts are. So it's a risk-based approach, I think, is probably what I'm trying to get at.
Brilliant. Thanks, Declan. All right, so here's one that's come through, which I'm going to have a go at answering. So it says, given significant funds are still being laundered in the UK, do you foresee more actions and regulations in the near future? So I think, yeah, absolutely, there are going to be regulatory changes. And at the moment, there is a consultation open by Treasury on the money laundering regulations. You've got about 4 weeks at time of broadcast to get your response into that. That's due, I believe, on the 9th of June. So if you do have views about the money laundering regulations, you've got a chance to respond to that consultation. Alongside it, actually, the Treasury is running a questionnaire on the costs of compliance to firms, which I think is a really important debate to have about risk reward in terms of cost of compliance. So I think it'd be really helpful for firms to make sure that you get your views heard in response to that questionnaire about costs of compliance. So that's probably the biggest change coming in the near future. We've also got the start of the national risk assessment process being updated. So that is another change that is coming. And of course, on the financial sanctions side, I think it's fair to say that that is a very, very fast moving picture, and probably further changes to both the legislation and the sanctions lists coming over the next few weeks, years and months. So let's move on to another question that's come through over the course of the webinar. So this is about gifted deposits, which is quite a tricky one. So the question is, it is very common for family members, those not involved in the transaction, to be gifting or lending money for the transaction. And so this firm says, we treat the party making the gift or lending the money in the same way as we identify a client and carry out source of funds checks. But the firm goes on to say, this can be burdensome, especially when there are several gifts involved in the same transaction. So the question is, are we required to carry out such extensive checks on parties which are not clients? So Declan, are you happy to give some thoughts on that one?
Yeah, sure. So I think when looking at sort of third-party gifters in, I don't know, a standard conveyancing transaction, again, the level of checks and the extent of your checks will all be based, again, dependent on risk, really. So if there are sort of higher risk factors involved, for example, if one of the gifters or donors was based overseas, you may consider doing more sort of enhanced checks, particularly if they're based in a high risk jurisdiction. We've obviously, in our sectoral risk assessment, we flagged pooled funding as being sort of high risk. Obviously, that's slightly different to your standard conveyancing, but again, it all depends on how much is being gifted and what the circumstances of that gift are. If it's a relatively low amount, you may choose to not get as much information. If it was quite a significant gift coming from sort of several different donors, you may choose to go into it in a little more detail. So again, it is all about that risk-based approach, and again, documenting your rationale.
Brilliant. Okay, we've got time for a couple more. Apologies, we are running over. So I'll give a few thoughts on this and then turn to Ross. So do you have any further information or inkling as to what the result of the AML supervision consultation, the AML supervision consolidation consultation is, or when we can expect it? So don't have any firm information. What I would say is those of you who read the Treasury's report on AML supervision, it's an excellent read. I'd recommend that you look it up. As part of that, Treasury said that they would be setting out next steps in due course, but they don't give any timetable on when we can expect that. And we don't have any inclination or further information as to the likely outcome of that. But anything that you want to add on that, Ross?
Just to say, I've got it up in front of me, and the exact quote in that report was, "We will set out more in the coming months about the future structure of the supervisory system following the consultation in 2023. So we definitely are waiting on tenterhooks to hear what the outcome's going to be. I suspect we're probably going to find out about the same time as the profession do.
All right, brilliant. I'm going to do one last question, then I'm going to look to wrap up because we're already a bit over time. So I'll let you have the final word again, Ross. So my firm does low value, high volume road traffic act cases. All are prosecuted by CPS and the police are aware of all clients' ID. Are we expected to do individual risk assessments for each new client, even when the overall risk is very, very low for each of them? So what are your thoughts on that, Ross?
Well, the good news is that in the ordinary course of matters, this would be outside of the anti-money laundering regulations. So you wouldn't need to do individual risk assessments on your clients. You're still required to identify them under the standards and regulations, but all of the requirements of the AML regulations won't apply to you. The thing is, though, it's important to remember that if this does, for example, stray into perhaps setting up trusts as part of a PI matter, or if you ended up getting involved in company formation or anything like that, that would take it into the ambit of the regulations, even though it's criminal road traffic matters, given where it's coming from. But absent of that, if it's just straightforward RTA criminal litigation, then no, you're outside of scope. The same thoughts that I've had before in terms of checking out whether your clients are subject to sanctions or not. I know it may seem a little overkill, but there is a strict liability regime in place. It is just as well to carry out that very quick free check to make sure that they're not designated persons. Otherwise, as I say, identify your clients, but do be reassured that risk assessments from what you've put there do not look like they're necessary.
Splendid. Thanks, Ross. All right, I'm going to wrap this up here because we've overrun by a few minutes anyway. But thank you so much for all of those who submitted questions. I'm sorry we didn't get round to answering all of those. We've probably got enough for another Q&A webinar, so we'll have a look at that. But as I said, this was a new format to just do a webinar purely based on questions and answers. And really hope that you have found it useful. But it would be great if you could give us a bit of feedback as to whether it's one that you would like to see again. And there should be a link at the bottom of your screen for you to give us some feedback. So do please give us your comments on the webinar. We've had a couple of questions come through about specific cases that you're involved with, either on the investigations or proactive supervision side. You can't answer in this forum questions about individual cases, but do please get in touch with the caseworker on those and they'll be able to come back on those specific points. So thanks again for your time, for attending. Thank you so much to my colleagues, Ross, Mandy and Declan. Really appreciate your time and hope to see you again soon. Thank you very much.